Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. On the docket today, first, Harvey Weinstein's lawyer is making friends and influencing people. Second, Miss Troconis had court today. She's the ex-girlfriend of Photos Doulos. Third, a Varsity Blues defendant takes a big hit. And fourth, the zero tolerance policies equal the death of common sense. And finally, our dumb criminal contestant of the day and our winner for the week. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. We are here today in a snowy Denver, Colorado, but we hope you are in warmer climates. As always, if you have not subscribed, please hit that little subscribe button, hit that like button, and hit that bell if you would like to receive notifications, and always leave a comment. We want to know what you have to say. First on the docket, Harvey Weinstein's lawyer. Now, Harvey Weinstein has a lot of attorneys. In fact, I believe we're up to 6. And that doesn't even include all the attorneys that he's fired. But Donna Rotunno is kind of the lead attorney taking the case on his case in New York. We've heard a lot about her. She has cross-examined the complaining witnesses very extensively. And for lack of a better term, done a great job when it comes to representing her client, regardless of what a pig a lot of people think that Mr. Weinstein may be, or in fact, very much is. Ms. Rotunno does a podcast interview with the New York Times, and she is asked basically, have you ever been the victim of a sexual assault? And her response was, is going to make people think that total victim shaming. I've been accused of that by many a person on the comments simply because I said these women are going to be cross-examined on why they would go to this man's room knowing what they know about Mr. Harvey Weinstein at the time. Let's face it, apparently everybody knew that this is the way Harvey Weinstein operated. And they went to their room, and the cross-examination was basically this was a mutual contract for these people. You give Harvey what he wants, and maybe he can help you with what you want, which is a movie career. So Ms. Rotunno is asked on this podcast, have you ever been the victim of sexual assault? And she says, no, I would never put myself in that situation. And the interviewer then goes on to ask her, well, are you saying that basically if a woman gets sexually assaulted, she somehow put herself in that position, whether it's to have drinks or agreeing to go to a hotel room? And Ms. Rotunno says, absolutely not. Just as we make smart decisions when we walk out on the street at night, I think you have to make the same decision when you're putting yourself in a circumstance with other people, Rotunno added. When we walk out at night, we look around. We make sure we have our phone. Some people take mace. We take precautions. All I'm saying is women should take precautions.
No, I'm not putting all of the responsibility on the woman. I'm placing responsibility on the woman. Women cannot be equal if women don't start taking on equal risk. Women want men to take on all the risk. They want to then put themselves in whatever situation they're in and then walk out and say, oh my God, I had no idea that was going to happen to me. You can't have it both ways. And when you're put in circumstances that you think are questionable or negative, or you don't want to be in, or you think this is the only way I'm going to get the job, we know that that's ridiculous. We know that if women stand up and say, I'm not going to take this, I'm not going to do this, you have other options. So
that's going to be basically the closing argument in the Weinstein trial. These women went up there, had a pretty darn good idea of what was going to be asked of them, and if they participated in any way, it was consensual. And then you have the emails over the course of the relationship with Mr. Weinstein showing that it was in fact consensual. These women having this ongoing relationship certainly does not bode well for them. Now, the prosecution in the Harvey Weinstein trial rested yesterday. And the defense began their case today, and the first witness that the defense called was a memory expert by the name of Professor or Dr. Elizabeth Loftus. She's from the University of California, Irvine, and she explained to jurors that receiving misinformation about an event, trying to remember it in therapy, and discussing it with law enforcement can all distort the memory. The doctor said she's seen a situation where people are motivated to want to try to remember more, leading them to fill in details and feel like the memories are in fact real. This expert also testified as a blind expert, just as the prosecution's expert testified as the blind expert. And that simply means that they did not interview or engage in any kind of analysis of the individuals making the complaints in this particular case. They're simply there to explain generally overall that sometimes the people don't have memories of something, or they have limited memories, that somehow your memory does not get better as time goes on. And if you are remembering these things, you're filling these in, oftentimes it's an urge to want to help out the situation, or you think that's the way it's been suggested to you over time. That's ultimately for the jury to decide. That's what the defense is presenting in this particular case. I've used experts like this before. Sometimes juries really think it's interesting. Other times juries say, no, it's not of any importance of all. But when you have a case where a lengthy time period has gone by and suddenly they just happen to have this memory and it comes back, that's when you call in an expert like this. Oftentimes, prosecutors want to bring in a therapist and talk about generally what's going on, and they're in fact treating the individual, but yet they won't release the medical records in regards to that particular therapy to see what was suggested, what did they originally say, what was added to it, who suggested something to the complaining witness. I'm not saying it took place in this particular case. I'm just saying generally that's what happens in these kind of cases. But at least I can say one thing is I am not going to be accused of victim shaming like Miss Rotunno is. Let me know in the comments below if you think Miss Rotunno is victim shaming, or does she have a point? Let me know. There's no right or wrong answer. Next on the docket, Miss Michelle Troconis had court today. She has a new attorney. She entered a plea of not guilty on the charges of conspiracy to commit murder. While she was in court, she also used a court interpreter. And as we mentioned yesterday, her new attorney kind of highlighted the fact that English is not her first language and she maybe didn't understand everything. And of course, they highlight the fact today that she needs the interpreter. So it's curious if this is the tack that the new attorney is going to make, that perhaps when she went in and did her 3 interviews with the police, that maybe she didn't understand everything, or maybe she misunderstood. She's not sophisticated and familiar with these big city ways of Mr. Photos Doulos, and she misunderstood everything. We'll see how that defense plays out as well. Now, Varsity Blues. Haven't talked about Varsity Blues in a while, but this is the case where the uber wealthy parents have, for lack of a better term, some pretty average kids, and they're willing to pay to get their average kids into great schools. And a lot of parents paid a lot of money to do that, and they all got wrapped up in it with this one particular advisor that was counseling students and had this, connect, so to speak, to get these guys in. That advisor's name was Rick Singer, and although he's pled guilty, has not been sentenced just yet. And the gentleman that was sentenced today was the gentleman by the name of Douglas Hodge. Now, he was a former executive, in fact, the president of PIMCO. And for those of you who are not familiar with PIMCO, it's a bond trading company, all right? Company's worth billions of dollars. I believe some of the founders of that company are worth billions of dollars. And what offended the judge in this particular case, as well as the United States attorney, was during the time that this was going on, where these payments were being made, of some $850,000. Mr. Hodge, in that particular year, made $26 million in income. So certainly, let's face it, these kids had every opportunity in the world to succeed. Okay? They probably had the best teachers, the best schools, the best tutors, the best of anything. And whether they're maybe just not capable of doing the work and couldn't compete, or maybe they were lazy because their parents gave them everything and the parents always took care of them. These kids were not motivated enough to work hard enough to excel to try to get into these top schools. Mr. Hodge had 7 children, and he paid $325,000 to Georgetown tennis coach to get his oldest daughter and son admitted as tennis players, and another $525,000 to get another daughter and son admitted to the University of Southern California as soccer and football recruits. Now, apparently, Mr. Hodge thought that since he went to Dartmouth and Harvard, that he had to have his kids in these really fancy schools. Now, I didn't go to any fancy colleges like Ivy League schools. And, the joke always is, how do you know if somebody went to an Ivy League school within the first 5 minutes of meeting them? Well, that's easy. They'll tell you. Okay? They think it's a really big deal. There's lots of people that I have met that have been Harvard law graduates. And the only way I would follow them into a courtroom would be out of idle curiosity, because frankly, they may be really smart, or at least everybody thinks they're really smart, but they're not that good. So it really doesn't mean much. But this case for Mr. Hodge is the kind of situation where sometimes you may just have to realize that maybe your kids have to work a little harder. Maybe your kids shouldn't be given everything and expect it to succeed. That's the beautiful thing about America. Nobody cares who your daddy is. Nobody cares where you went to school. Nobody cares where your daddy went to school. It's ultimately a meritocracy. The cream will rise to the top. And like I said, whether these kids are just average or maybe they're just lazy, and that's why they couldn't get in on their own. But they had every opportunity to succeed with parents like this, and this guy thought that, frankly, the rules just didn't apply to him, and he's going to get his kids in, and then they'll be able to succeed because why? They went to all the fancy schools, therefore they must be smart. Now these kids are branded as basically being not good enough, okay? And this dad should have just realized that maybe my kids aren't as driven as I was or he was, so that they have to succeed and or fail on their own. Anyway, the judge wasn't buying what Mr. Hodge was selling. The United States attorney wanted 2 years in prison for Mr. Hodge. Mr. Hodge wanted less, in fact, wanted in-home detention so that he could continue to reside in his California gated community mansion, and the judge said no. Like I said a moment ago, Mr. Hodge made $26 million during the year that he made these payments. He also took that as a tax deduction on his income. This was the harshest sentence to date in the Varsity Blues case, and Mr. Hodge is off to the Federal Bureau of Prisons for the next 9 months. Now, what's the significance of that? And I think we've talked about this before. In the federal system, you don't get good time credit until and if you serve at least 1 year and 1 day is your sentence. So in a 9-month sentence, guess what? He's going to serve the entire 9 months. The last 6 months of it are probably going to be at a halfway house, but he's still going to serve that 9-month sentence. Next on the docket, zero tolerance equals the death of common sense. A lot of people may not recall, but years ago when there was a trend of children bringing guns to school or gun violence at school, that schools implemented zero tolerance policies related to guns. And over the years, there's been cases where obviously kids should not bring guns to school. I've had cases where kids have brought guns to school. Literally, I had a case once where the kid found it and took it to school in his backpack. Had cases where kids took the guns knowing they were going to take it to school. Guns don't belong there for those young juveniles. The youths of America oftentimes lack the frontal lobe development that they should exercise good judgment, so they shouldn't be taking those things to school. Well, like I said, it got crazy. There were incidents where kids were making their sandwiches in the shape of a gun and they were getting suspended. Here we have a case from Pennsylvania, and a 6-year-old girl who suffers from Down syndrome apparently made a gesture at a teacher and said something to the effect of, "I shoot you." Well, the teacher, who's dealing with a 6-year-old with Down syndrome, apparently thinks it's appropriate that she needs to report it through the principal. The principal then, of course, because they have to follow policy, then reports it to the police. The police make a record. Nothing's going to happen. But the point of the matter is what the hell is the school district doing in a situation like this? This is called common sense. I would get rid of the teacher. I would get rid of the principal and fire both of them, because clearly they don't have enough common sense to take care of a little simple situation like this, given the circumstances at hand with a 6-year-old who suffers from Down syndrome. Are you kidding me? I doubt the kid even understood what was going on or what the implications were at all. But this is what happens when you have bureaucrats making cookie-cutter rules and regulations to apply. And when bureaucrats are too afraid to exercise common sense that they follow idiotic policies because they're afraid of getting fired, guess what? They need to be fired. So the Tredefen School District in Pennsylvania hopefully will do something about this school teacher and fire the teacher and the principal that thought this warranted a call to the police. The death of common sense, ladies and gentlemen. Next on the docket, our dumb criminal contestant of the day, a gentleman by the name of Kaiser Pontoon. Yes, Kaiser Pontoon, he is a high rep learner. And why is he a high rep learner? Well, he apparently doesn't get the fact that if you break the law, you're going to be arrested. Mr. Pontoon has now been arrested 66 times, and he's only 28. Not that you should ever get that high, even at an older age, but it shows you that he just does not get it. Mr. Pontoon over the years has been arrested for failure to appear, drug charges, being a felon in possession of firearm, as well as eluding police officers. Mr. Pontoon is our dumb criminal contestant of the week because, frankly, he must just be dumb. And what's even scarier is that a lot of the new bail reform laws is going to make it even easier for Mr. Pontoon, because before a lot of these criminal justice reforms were coming out, people actually had to post bond. You had to post money to get out of jail, and if you didn't show up, you lost it. But now it's literally everybody gets a personal recognizance bond, and you promise to appear, and if you don't, so what? Nobody cares. Just ask the people of the state of New York how all that is working out for them, because now the state legislature is trying to repeal their bail reform efforts because crime has gone up, failure to appears have gone up, and nobody even gives a damn about going to court anymore. So obviously, as a criminal defense attorney, I have argued for bond many, many times, but the key factors that the court has to consider are the likelihood that the defendant will in fact appear, and what is the risk to the community. The bond should be no greater than necessary to assure the appearance and the safety of the community. And sometimes that warrants a PR bond, and sometimes people are just dangerous. But not everybody should get a PR bond in every situation. And I'm talking to you not as a criminal defense attorney, but as a member of the community. Common sense must prevail, ladies and gentlemen. Common sense. Where the hell is it going? I have no idea. So, we have Mr. Pontoon as our dumb criminal contestant of the day. We had our gentleman who liked to have intercourse with the front grille of a van. We also had our unknown contestant who stole $17,000 on his first day of work and took everything except the video of him, so at least they have an idea of where he might be. And we had our drug contestants who had their bags that said drug bags, which obviously led the police to search and find the drugs. And let's not forget the nice lady who liked to smear dog feces on her boyfriend. I know it's another tough call, but today we're going with our unidentified convenience store worker who stole $17,000 worth of money and goods from the convenience store, including his personnel file, so they really have no idea who they're dealing with, other than this mugshot-looking thing from the surveillance camera. Take a look at that. He's our winner. Let's all give him a hand. He deserves it. Thanks for watching. Have a great day. We appreciate you taking the time to do so. We know you have lots of options to choose from on YouTube, and the fact that you take the time to watch us does not go unappreciated. Thank you and have a great day.